So we've talked about the legal, procedural, and now we've seen him playing the sympathy card. That started yesterday, but also today, on the floor of the House, Diana, he did, bring the president into the room in his defense, saying that what he has done is no different from what his boss, the president, has done. And if he's learned anything, he's learned from the best. There was quite a bit of, dragging into the mud today. So politics, sympathy, but also one wonders, what does this mean for the relationship between the two going forward after what we saw in the House today, where he said, well, okay, it's not just me, but it's him too.
Well, it feels like a divorce, and nowadays our court says, as long as it's irretrievably broken down, please, love no longer exists. Let humans live in different spaces. And this looks like that type of a union. It didn't start yesterday. Sunday, there was an apology.
Yes.
There was a public apology in church. There were sermons that were preached in our altars, and both the president and the deputy president staying with their families. Now, I think for the deputy president, particularly yesterday, he decided to prosecute his defense to the world, to give us a narrative of this marriage. The minute it breaks down, we went to court, the more powerful one will definitely win. But here's my story. Because look at it. He had sentiments against the Speaker of the National Assembly, who was supposed to be the arbiter today, the Speaker of the Senate.
Who will be the next
arbiter.
Right.
He was already in court saying there is no way that my impeachment can be fair, seeing as these are the utterances of the Speaker of the National Assembly. Then in the middle of all that, yesterday when he said he's not answering questions, he answered one question. Is the president involved? Yes. So even if he was to survive, say, in the Senate or within our courts, how would they relate? Would he ever sit in cabinet meetings? What would that relationship look like where they are both getting intel and so on?
And they also sit in the National
Security Council together. So when you think about it, what do you do when a relationship has irretrievably broken down? What duty do our leaders have to us as a citizen? That they can no longer sit in the same pot. Do you break the country because of your relationship as the two people? Who else do you bring on board? I think those are issues of leadership and integrity, which we do not have as yet. Even with this new bar, we do not have that as yet. Because how much of our time and resources as Kenyans have been wasted? This has been simmering for a very long time. You've had members of parliament who are opposing the motion say that this should have gone for arbitration, alternate mediation by our religious leaders. They can see what it is. It's a dispute. It is not clear what the dispute is about. It has not been disclosed. It is not anything that has been presented to us in the last 2-3 days around what the root cause of this dispute is. What happens then? How do we determine who has the higher moral ground to stay and who leaves? And leaves on what terms? So I am at a loss, because when it gets to that level, I would have expected people to honorably resign.
And he said, he dug his heels in last night and said, I know there's people who thought that I would, and his exact words were, I have no intention of resigning. And that was followed by, a chuckle that has now gone viral. So like you say,
yet this is a precedent that has been set.
Yeah.
the final term of President Uhuru and then Deputy President Ruto, how many governors and deputy governors no longer see eye to eye, yet they continue every day to utilize taxpayers' resources to do not to serve the people. If anything, is to keep showing their might, draw daggers at each other.
Yeah.
There's something very, very problematic in that particular relationship. There's something very, very problematic in that particular architecture and framework of our leaders. But having drawn the president, imagine how right now the president is very powerful. Because, in my opinion, the 281 votes are a show of confidence. If the allegation put forward by the deputy president are true, then the president has a lot of confidence in the National Assembly to give him a supermajority to prosecute this impeachment and any other. All state power and authority will very soon be coalescing, kowtowing, venerating before the president to deliver whatever must be prosecuted. Who will check the president? Who will check the president moving forward? We questioned where we were going when the broad-based government was established. And we were told the democracy within parliament would remain. Azimio would remain Azimio, Kenya Kwanza, and their shares would remain Kenya Kwanza. They are one. I'm hoping that soon there will be another hearing where we will hear of the new agreements and the new subdivision. You know, survey. Our Kenya is being surveyed every time, divided, subdivided, multiplied, square-rooted, and so on. There's something very wrong. These are not our national value, our democracy, maybe even at risk.
And that's an interesting point you mentioned about also, testing that muscle and that majority that you have when you've got 281, members who then vote to impeach. That says something, and maybe that's a muscle that can be exercised going forward. But I want us to stay on what you were saying about, the relationship between the two that has seemingly irretrievably broken down. Charles, when we moved from what we had before to the Constitution of Kenya 2010, we were hoping to sort of solve some of these problems that we had when we had a vice president. Now we have a deputy president, and it would seem that the relationship between the deputy president, or shall I say, the president and his principal assistant, whether it was a vice president then or a deputy president now, has always been fraught with challenges. I mean, literally, throughout the history of this country. And it would seem that the Constitution of Kenya 2010 might not have found a solution for this one. In 2013, when we had the first, elections under the Constitution of Kenya 2010, we saw the relationship good in the beginning, but started to get prickly, maybe, within the first term. This one as well, although this one is much sooner. So how do we crack this? Because not even the new Constitution, and I, say new relatively, seems to be able to solve this problem.
Yvonne, it will be good to look at the broader picture. It's not only Kenya which has this kind of problem. About 12 years ago, when the president of Malawi died, he was called Bingu wa Mutharika, his deputy president, who took over, Joyce Banda, was actually in a different party. She had been kicked out of the ruling party. She had formed her own party. And if you remember, those of us who are following the news at the time, that there was even an attempt to try and have some kind of palace coup and prevent the vice president from taking over of Malawi because he was no longer part of the party machinery of the president. She was just operating quietly. She was not able to attend cabinet meetings. We remember in the second term, of course, of Uhuru, that Deputy President Ruto was removed from the job of chairing cabinet committees. Right. And it was given to powerful cabinet secretary, You remember the situation at the time. So it's not just a Kenyan issue. It's not only an African issue. All countries with a presidential democracy where the running mate is voted in on the same ticket with the president, this challenge occurs from time to time. My own scan of history and geography, I feel, has led to the conclusion that the way to deal with this situation is to have strong political parties. Because when you have strong political parties, they negotiate and they take care of interests. Even in parliamentary democracies, you have political parties that do so. But where you have you don't have very strong political parties, they tend to focus on the individual. Then it becomes easy to have this kind of problems which are at the level of individual difficulties, then becoming unsolvable through ordinary political engagement and haggling between the major political players. And this is something that is expected to recur if the Deputy President Rigathi is successfully removed from office. Even the person who comes in may still face the same challenge. They always start as the best of buddies, but things start changing. So,
but must we then continue to paint it that way? Because former President Uhuru and Deputy President William Ruto were, like you say, best of friends. They were wearing matching shirts and ties, and both of them are rolled up, or, you know, sleeves rolled up, and they were doing all of these photo shoots where they looked like it was a bromance. And we saw the same thing again this time. Is that depiction of this relationship necessary? Because it now almost, from now, like you were saying, hindsight, it just feels contrived. Like, okay, let's let's go out there and show everybody on Instagram that we're looking good and we're, buddies. And
political succession politics is interesting. If you look at the case of the United States of America, who was the vice president of Barack Obama? It was Joe Biden.
Yes.
When Barack Obama finished his second term, the expectation was that Joe Biden was going to take over. But Hillary Clinton was kind of like more popular with the party people. And so Joe Biden ended up losing in the party primary. I have found that political succession has been one of the triggers of the beginning to separate, the separation that has happened between the president and the deputy president. For Uhuru Kenyatta, there were issues of succession politics. You remember he started by saying his deputy alikuwa na tanga. He was going around the country politicking, and Uhuru felt he needed to be given time to establish his legacy. Right now, there's also been the uncertainty, because when Rigathi was appointed by Ruto, or nominated by Ruto to be his running mate before he was elected by Kenyans, there was this question that in the agreement with the people of Ford Kenya and ANC, they had said that Rigathi is not necessarily my successor. He's my deputy, but not necessarily my successor. There would need to be a bit of jostling to determine who will succeed President William Ruto. So you can see, when people start thinking about succession early, it's one of the places where disagreement starts happening. And in Kenya, where we don't have...
We're always in perpetual
Yes,
election.
exactly, exactly. And so every move of your deputy is being tested, both by the president and by the other people who are jostling for power, based on, is he trying to secure a political base for his succession? And so I think this issue may recur until such a time as we have strong political parties, so strong that, as has happened in ANC in South Africa or with the American parties, that the fact that someone is a deputy president does not necessarily mean that they will ascend to the presidency. If the party has strong internal democracy, then any member of the party is comfortable that when the time comes for campaign, any of us can get there.
But they make statements like yangu kumi, yako kumi. And so, it's sort of naturally assumed that is what it would be. But we would imagine that, the laws of the land created a deputy president to be a principal assistant, right? And maybe in some ways designated survivor.
Yeah.
To be able to take over should anything happen. But you raise an important point about, that it should be anybody from the party who can then succeed. I want to just read out a message, and this is a post by the now impeached Deputy President of the Republic. Is quoting a post is put out on social media this evening after that vote was taken by the National Assembly. He quotes 1 Thessalonians 5:18, which says, "Give thanks in all circumstances, for this is God's will for you in Christ Jesus." The second memory verse that he puts out is Jeremiah 30, verse 19, which states, "From them will come songs of thanksgiving and the sound of rejoicing. I will add to their numbers, and they will not be decreased. I will bring them honor, and they will not be disdained." And he ends the post with, "It is well." So, it's been a tough day. Bad day in office, if we can say, to say the least, for the Deputy President today. But, just to carry on and talk about the role, because, so where do we go from here? Because, he's not resigning.
He's still the Deputy President.
Yeah.
Through the entire process of impeachment, he enjoys the full constitutional powers of a Deputy President. If he goes to the High Court, gets a stay, he's still the Deputy President. And then if he vacates, that position will be vacant for some time.
Right. And we're now going to see, if we haven't, if you are in the political world, there's ramblings already about, what happens next. And that's an important point. So what happens now, Charles, if the Senate upholds the resolution to impeach?
And removes the Deputy President.
Yes.
So the first thing that can happen is he might go the way of Kawira Mwangaza, the governor of Meru County.
And many others.
Yes, she's in office after having been removed by the Senate, courtesy of court orders. And if you get court orders in the High Court, and the High Court ends up deciding against you, you can appeal to the Court of Appeal, you can appeal to the Supreme Court. So if you have a great team of lawyers and also you have happy circumstances and you persuade the judge, you can still be in office for quite some time. It happened to Wambora and it has happened to Kawira Mwangaza now. If you don't persuade the court to give you an order of stay, as happened in the case of Sonko, then the moment the Deputy President is removed from office by Senate resolution, the Constitution says that the President has 14 days, 2 weeks, to nominate a new Deputy President. And then that Deputy President, the name is forwarded to the National Assembly, which then has 60 days to vote on that Deputy President. If they vote to reject that appointee, then you'll have to appoint someone else. If they vote to accept, then you get a new Deputy President. That is really the situation. And that new Deputy President then enjoys all the powers and benefits of a Deputy President who has been elected, even though this one would have been only selected by the President and approved by the National Assembly.
Yeah, and you wanted to?
Yes, just in between there is, remember, whoever the president nominates ought to be somebody who merits and has the same threshold as if as the person he would have nominated at the point of election. And the body that clears that is no parliament. The body that clears somebody to be an electoral candidate for presidency is the IEBC. Okay,
an IEBC which at the moment
is not constituted. Therefore, unless we have a new advisory that says in the absence of the IEBC, we go back to Parliament, which is the representative of the people, and they can approve and they have the powers and the skills of IEBC, then right there we have a problem. So before we get our next nominee, if the Deputy President is impeached by the Senate and court processes also say that then he ought to vacate office, for that nomination to go through, we will have problems of constitutional timelines.
although the constitution provision that talks about the appointment of a new deputy does not mention IEBC. So it's an interpretation, but personally I don't agree with that interpretation for the reason that the constitution speaks clearly on the topic. It does not imply, even though I've seen some lawyers have argued as you have indeed, so it's a legitimate argument, but I think it is a stretch because the constitution just says the president nominates. The way he nominates other people, he can nominate, and parliament is a constitutional body. The speaker can determine whether that person reaches
on this one of the things that will strengthen our constitutional democracy is respect for institution. The deputy president, whether nominated midway, still for them to carry that weight, I think cutting corners would even create more problems.
I think what I'm saying is that it's not corners that are being cut. IEBC exists for one purpose, two purposes. One is to manage elections, and second, boundaries. This process of appointment of a deputy president
is an electoral process.
Is not an electoral process.
It is an electoral process.
It is an appointive process that involves the president.
No,
and then
Senior, here let us agree. Let us agree to disagree.
Okay,
let us agree to disagree.
In what part of the law would you say this one particularly falls as an elective process?
You do not.
There's Article 149,
yes,
which talks about a vacancy in the office of the deputy president, which says within 14 days after a vacancy arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. If a person assumes office under
when you read that particular clause,
yes,
you must read it together with the original nomination of the deputy president. Okay? Because that particular replacement, when they are replaced, they will have the full powers as the person who was nominated on the ballot. And if anything that was to happen to the president, they must meet the entire criteria of who qualifies in this country to be the deputy president. Everything around citizenship, they're a voter, all those. And the institution that has that power is which institution? It is Parliament. So on that basis, I think I would be worried if the president was to just nominate and not subject that particular name before handing it over. It's the same thing as around public participation. You cannot read one clause of the Constitution without the other clauses that are linked to it. So that's my own reading and interpretation of the process and where we are supposed to move from here.
Okay, your thoughts on this, and then we can move on.
Yeah, I think it's a stretch. I think we have enough issues in the Constitution that we are testing without the need to add extra requirements that are not in the constitutional text. We know right now we don't have an IEBC. The commissioners are not in office. So an interpretation that says you need IEBC to follow the procedure under Article 149 would basically be giving the president an opportunity to deny us a deputy president despite explicit constitutional text. There's no single provision, I've looked at the Constitution, that says that this process of appointing, because it's not election, it's very clear in Article 149 that it requires IEBC. I had that interpretation, first of all, from a lawyer in the public space, and I immediately thought it was suspicious. I actually had to go and restudy the Constitution because I understood what the Constitution said. I think it is a stretch. I personally don't agree with it. I think Article 149 is clear. The role placed on institutions that are given a role in the replacement of the deputy president are two. One, the president is an institution, and second is the National Assembly. They have been given that role, and I think they are able to discharge it. One of the problems in the Constitution is when you strip organs that have been given power of their mandate. Parliament has been given the mandate. It can interpret the constitution. It knows who is qualified to be a deputy president. The president can also exercise his mandate. And if any of them fails, you can go to court. You don't need the IBC. It doesn't state so expressly. It doesn't state so in the standing orders. It doesn't state so anywhere in regard to this process of Article 149. But I think there are enough interesting issues regarding the process that is going on that at this moment we can be reflecting on, and we leave that one for debate maybe by lawyers at a future occasion. It is an anticipation that is going much further ahead. For now, the interesting thing is the Senate is about to be seized of the impeachment resolution. I would like to know how the charges would be framed. Would they be exactly identical? Would they have any scope to try and revise or amend some of the charges?
Can they do that?
I don't think they can.
Okay.
But we definitely saw in the National Assembly that some of the arguments that were being raised, for example, about women being called names that were not very respectful, were not in the charges. They've also included in the proceedings in Parliament the statements that the Deputy President made yesterday while he was addressing the public, and also his newspaper defense. If they find that there is something stated there that constitutes a self-implication or self-incrimination,
Okay.
are they allowed to bring it up? I think those are now the issues that the Senate would have to deal with. Does the Senate have the power to consider procedural questions of the National Assembly, or is that only for the
courts?
For the court.
Okay, I'd like us to speak about the courts for a moment, because there's a question here asking whether the DP's case will start at the High Court or at the Supreme Court, owing to the high office occupied by the person, or is he a person under the law? I'll start with you, Charles, and then I'll come to you, Diana.
Yeah, again, the Constitution does not say anything expressly about the process. When the Constitution talks about the process of impeachment, it doesn't anticipate that you will challenge the impeachment process in court. So you go to a different chapter of the Constitution, which says that anyone who feels that their constitutional rights have been violated can approach the High Court for redress. And then from the High Court, you go to Court of Appeal and Supreme Court. And we know that in previous occasions, when there was an attempt to approach the Supreme Court directly on matters touching on who is qualified to hold the office of president or deputy president, if it was not in the context of an election petition after the election, a presidential election petition, the Supreme Court already ruled that all those cases should start in the High Court. So the conclusion I would make, based on the current decisions of the Supreme Court and of the High Court and the current practice, is that any challenge to this impeachment process would have to commence in the High Court.
Okay, so what we're saying is the courts do not, aren't in terms of people and rank. Everybody is, I imagine, equal before the law, and so you start at the High Court and make your way up.
The Supreme Court is only has direct jurisdiction to hear matters only for presidential elections.
And interpretation of the Constitution, I believe? Is that correct?
Advisory opinion at a certain level. Interpretation of the Constitution starts at the High Court.
Okay.
But let me just go back to my earlier point. Whenever cabinet secretaries are nominated, or any other nominees, part of the process when they go before Parliament is, say, for your criminal record, DCI must clear you. For your ethics and everything, EACC must clear you. For you to merit to be somebody who is a president or deputy president, IEBC would need to clear you. So the question is, that clearance, can it be issued by the Secretariat, or is that a mandate of the commissioners only? And we may be worried that, now we are making it complicated for ourselves. No, we have not. The political class has denied several constituencies, several wards, representation for a very long time. Out of things that they would have resolved already, We are being denied the right and access to delimitation because of boundaries. But the Constitution has a way of getting back at the people who think that they can abuse it.
Yeah, and this is definitely going to be a point of conversation in this going forward. Allow me to read, I'll try and read excerpts of it from lawyer Steve Ogola, who says, and I'll quote, he says, "I have my anxieties about the conversation that demands IEBC to approve nomination. What is the purpose of gazettement? Is it not to bring to the public's attention the nomination for election or notice of appointment following an impeachment? The Supreme Court, in Advisory Opinion number 1 of 2015, clarified that the guiding law on replacement of deputy governors is found in Article 149, which provides a complete framework for replacement of an impeached deputy president." So it's a long one. Perhaps I'll read excerpts of it. He says, "My view is that parliamentary vetting of a new DP nominee following an impeachment serves the same purpose of ensuring that the nominee has qualified on the threshold. During election periods, IEBC does the vetting and gazettement. One has to question the rationale for demanding a second vetting by IEBC, especially where the Constitution and Elections Act does not demand it." But clearly, I think from what we can see, there's quite a bit of feedback and views on either side of this one. Definitely a point of conversation going forward. I want us to now just maybe start looking at where we go from here. So we've said, okay, it is the Senate that's going to, hear this matter. And because in so many ways, we're testing this for the first time. This is the first time we have exercised Article 149 and everything that comes with it. Hence the debate we're seeing now over, what the next steps will be and whether the Senate will be able to consider new grounds. I mean, if the Deputy President says something more in public going forward, can they add that? Perhaps can the High Court also, I don't know, are the courts seized of matters that take place in the public domain, or do they only deal with what is brought before them? To the extent that, let's imagine, the Senate approves the resolution made by the National Assembly and votes for his removal, and then, the now ousted Deputy President says a couple of things in the public domain, has, a rally, and then this matter goes to court. Does the court say, okay, yeah, this is the petition you've brought before us, but hey, we heard you saying this and this and this, and this is suspect, and so what happens now? Because this is being played on both fronts.
Yeah, I think the concept is called due process.
Yeah.
And the concept of due process means you have to give someone an opportunity to follow a process with a fair hearing, kind of like guarantees, and then to defend themselves. And that is why even in normal court cases, you can't just introduce a new issue in the middle of a hearing that you had not pleaded. So there's a lot of emphasis on pleading, on giving notice to the other side so that they can prepare their defense. So when you do a simple reading of the provisions of the Constitution and the standing orders of both the National Assembly and the Senate, the conclusion is that it is a process that starts in the National Assembly. So by the time you get to the Senate, the charges that are being considered are those which were approved in the National Assembly, even though the National Assembly does not so much approve the charges as approve a motion which contains charges. Yeah. So to introduce new charges or even new bits of evidence that were not considered in the National Assembly is likely to be frowned upon by the court if the Speaker of the Senate was to accept that. There may be a few special exceptions, but it is not contemplated to be an ordinary thing. The second thing that is interesting is that under the standing orders of the National Assembly, a special motion normally, once it is deliberated on, you cannot bring another special motion of the same kind within 6 months or within that particular sitting, that session of the House. So, of course, if the impeachment motion was to, the impeachment resolution was to fail in the Senate, even if a new issue has been discovered, you may need to wait 6 months, which is what has been happening in Meru. Every 6 months, they have produced a new motion. Yeah. They are now in the fourth motion, and who knows which other motions they'll produce.
And that's interesting. Diana, look, all of this is not happening in a vacuum. There's a context and there's a situation the country finds itself in right now. So this impeachment process coming in the wake of the protests of June, July, which were calling for, better governance. And a little bit of that was seen over the weekend, during the public participation exercise. So how do we treat what's happened at the National Assembly today in the context of the mood in the country at the time? Because, whilst this is a process that is well outlined in the law and happening in the National Assembly and the Senate and perhaps the courts, who knows, but it's happening in a background of a country of people who remain displeased. If we didn't think they were still displeased, it was shown and it was very evident and manifest on Friday and Saturday, particularly on Friday. So, talk to us about where we sit right now.
We will see a lot of collision between the direct power held by the people and the delegated power that is held by our institutions, and especially Parliament and the judiciary. For what has happened in the public domain, whether it's from June, July, August, and has gotten us to this particular impeachment motion, for that to find its way around because what will be discussed will be mainly fair administrative action and access to justice. That will be something that can only be brought forward in the best way possible by the drafting of the lawyers. If they are able to show all those linkages, plead that specifically, and it's either side. I suspect Parliament will plead what the Deputy President did yesterday, prosecuting his case in the public instead of within Parliament. This other side may bring all these other facts. At that point, the court, what is pleaded, they will have to discuss with that particular context. Now, let's come to what has been happening in the public. Now, in my opinion, what we saw during the public participation for the impeachment of the Deputy President is continued displeasure and discontent of the people with the institution of Parliament and the institution of the executive, very, very loudly. Unfortunately, I do not think the people are being heard. Not in the impeachment process, because there have been very, very many administrative and legislative processes that have happened since the protest. But all along, you look at them and for everything, whether it is Schiff or Shah, Adani, we end up in the judiciary. For this impeachment, even the Deputy President will end up in the judiciary. Everybody is going to the judiciary. There's only so much the judiciary can do. And somebody has just written to me when I asked, what do we do when our representatives are no longer representing us? Have we surrendered our power completely? And I say power to be violated, power to be oppressed, power to be tramped on. I think we will see a lot of reorganizing of political democracy in this country. There is a likelihood of an opposition emerging outside of Parliament to just make things uncomfortable. I foresee public participation becoming the new frontier for people to organize themselves and very, very strongly share the sentiment in a similar manner as happened with Reject the Finance Bill. Because if we are not being heard, there are issues that people will let go, but there are others they'll be like, no, this is the only way you get to listen to us.
Is this an avenue then with the public participation bill that is now, sort of gathering views, and it's not been passed yet? Is this a moment then to start to strengthen that? Because here, just like with the Finance Bill 2024, 2023, and many other laws that have been passed, is where, it would seem the crux of the matter is this an opportunity to start to shape that? Because up until now, it's been left to the court's interpretation. So it's still not something that we have, fully sort of exemplified or expressed, as a foundational principle of the Constitution.
It is an opportunity to try and consolidate all the interpretation, the aspiration that we have around public participation. But we're handing that to who? To who to enact? To Parliament? When trust is broken, I would actually say this is the worst time to bring a public participation bill, similar to the bill on protest, conflict of interest.
When would be the right time? What would be the right circumstances?
When we have a parliament that shows confidence, that people have trust in, that that particular parliament represents them, listens to them, is genuine, transparent, and accountable around the power that they have.
And if that doesn't come?
If that doesn't come,
do we give up on public participation altogether?
We keep creating jurisprudence and imagining it on our own way. I doubt this would be the place, because the bill that is currently being drafted by the Attorney General is a third bill. There's a bill in the Senate, there's a bill in the National Assembly. Which bill is the public participation bill? Remember, even with this particular motion, the majority whip reminded them, can we do public participation because of the court? Not because that we want public participation. I am not sure this is the time to bring a public participation bill to Parliament, but we will engage nevertheless, because it's a constitutional institution. When they table bill, like for me, I engage with all of them, where they listen to just a comma. We throw our Bible verses and constitutional articles on our social media. And then the other times when they actually meaningfully engage us and take our views, we are like, finally, we are contributing to building a nation.
Okay. Interesting. You want to talk a little bit about that?
I think the first article of the Constitution, Article 1, talks about both direct and representative democracy. And I think neither can substitute the other. You need both. If the representative democracy institutions are weak, it's not possible to have such strong direct democracy that you can do without the representative democracy. And I think that's what Diana is pointing out, that if Parliament is weak, even when you do direct democracy, at the end of the day, that direct democracy is going to be processed by that same Parliament. And you can't overthrow a government in the streets. You can have protest marches to express a lack of confidence, but at the end of the day, other institutions of government have to come in. So I feel that it is an incremental process. There has to be continuous effort to improve both the direct democracy, and public participation is one of the mechanisms that is quite effective lately of direct democracy. Referenda is another, and there are various others, including sending, even the elections that we have every 5 years. And I think when the representative democracy is not working, we as Kenyans need to improve in the way in which we select our representatives. We have to strengthen our political parties. We have to encourage people of integrity and capacity to come out and run. We have to demonstrate our unhappiness with those who either steal public funds or don't fulfill their promises politically by voting them out of office. And if you do that consistently every 5 years, eventually you'll get the right kind of people. It may take longer, but you have to do it. And then, very importantly, our Constitution foresees that our principal organs of representative democracy or government, that is the executive and the legislature, will fall short on several occasions. So they have designed a mechanism of constitutional commissions and independent offices. These constitutional commissions, who is the one who staffs the constitutional commissions? Parliament is involved. So if Parliament is completely unable to do its job, like now to get IBC commissioners, we are in a crisis. For more than 2 years, we have IBC was meant to do boundary delimitation exercise this year. They were meant to do by-elections. They're not able to do it. But to the extent that the constitutional commissions and independent offices can also be strengthened, they may help when the representative institutions are not working very effectively. They may help to safeguard constitutionalism. And so we also need to put a lot of pressure. Like right now, several constitutional commissions, their terms of office of several commissioners have come to an end. We need to put a lot of pressure to ensure hygiene in the process of replacement, and court orders have to be followed, the existing court orders for recruitment of IBC commissioners that they have stalled.
Yeah.
And that's part of the problem.
I cannot end this conversation without, getting in this question from someone who wants to know what the timelines. I know you've talked about now we're going to the Senate, but someone saying, so now National Assembly, we know that in 2 days.
Even tomorrow.
Even tomorrow, yes. And usually the law says
tomorrow.
Within, so it could be.
Probably it's already sent.
It's probably already sent it.
At the door.
We will wait to hear whether the
Yes.
Speaker of the Senate will then, confirm receipt of it.
Yes.
But so now we're going to the Senate, and then we're going to.
At the same
then
time, we are in
see-
court.
We're in court as well.
there
Yeah.
are
So what
court-
is the timeline towards, all of this? Because yes, there's of course fair administration of justice, and everybody must feel like they have exhausted, all avenues.
Yes.
But there is a sense in which Kenyans are wondering if we're going to be, held up in this conversation
So
all the way to the Supreme Court. What are the timelines looking like to the final resolution of this matter?
So there are several court cases that
Yeah.
have already been filed.
Yeah.
There are some coming up as soon as tomorrow, as early as tomorrow, later this week in Kerugoya, in Nairobi. They are numerous. They've not yet been consolidated. And while the Senate process is commencing, we expect this week the next drama will be the drama of court, to see whether the court processes will question or impugn the process of the National Assembly. Will they stay or pause the process in the Senate, because they could do so? And this is the first thing that will affect the timeline, what the courts determine in the course of this week. If the courts intervene, then this process might end up in some kind of stalemate, going on for months on end. If the courts don't intervene, then the Senate process should be done within the next 2 weeks.
Can the court stop a parliamentary process? Aren't they supposed to be, separate but equal arms of government?
Depends on what is pleaded.
Okay.
Yes, and the courts have
Fair
previously
point.
stopped parliamentary processes. There's something
Which
called
parliament
the
has
doctrine.
said?
There's something called the doctrine of institutional committee. It says, can we respect each other?
Yeah.
Parliament, executive,
You wait until the
judiciary.
matter gets to you.
But
And then you can
the
handle it.
courts have on occasion done so, and they have distinguished between two kinds of parliamentary processes. Legislative processes, where they have said generally the matter is not ripe for determination until Parliament finishes its work, with the exception of BBI, where they intervened while Parliament was going ahead with its work. And second is other processes which they consider quasi-judicial or administrative. For administrative processes, they say the court can intervene at any stage they find the Constitution is being violated. So if they are convinced the Constitution is being violated, or there is what you call prima facie case, there's a strong case that the Constitution may have been violated, they may intervene and stop the process. This happened even with Kawira Mwangaza. The first time he was impeached by the County Assembly of Meru, the process was stopped by the court. They had to go and redo the process afresh. So it is something that is conceivable. And that is why the answer to the question, how long will this process take, is that it's indeterminate. It depends on so many factors. But if nobody interferes with the ongoing constitutional process in the Senate, within 2 to 3 weeks, the Senate will have finished its job, either rescued the deputy president or convicted him and removed him from office, and then now he will be a politician who cannot take another political office unless he challenges that impeachment in a court process and the court overturns it, which can also happen. So those are the processes that are going on. We may be focusing on this drama for weeks or for months.
Yeah.
Yeah. And especially if you plead anything, access to justice is a fundamental right.
Right.
Fair administrative, it's in the Bill of Rights, so the courts will intervene at any given point. Let's wait and see.
Yeah.
Let's wait and see.
Yeah, but it would be important to buckle up for what could possibly be, you know, a very long ride.
Yes, and our lawyers are good. They will keep us very busy.
Yeah, and there's quite a few on either side of this. Those representing the National Assembly, at least so far from the list we've seen, and those who are representing the embattled Deputy President of the Republic of Kenya. So that concludes our coverage of what can only be termed as an historic day, and that is on this 8th day of October. A day that will go down in history when the Deputy President of the Republic of Kenya was impeached by 281 members of National Assembly. The first Deputy President under the Constitution of Kenya 2010 to be impeached. Next, it'll be the Senate and, of course, what happens thereafter in the courts, or perhaps not. But, of course, watching what will happen within the corridors of justice for the cases that have already been filed there. That's our special coverage that started bright and early at 6 o'clock this morning, closing now at about 11:30. Thank you for watching The Explainer and indeed our special coverage of the impeachment of Deputy President Rigathi Gachagua on this 8th day of October. My name is Yvonne Okwara. Many thanks to our guests, Diana Gishengo and Charles Kanjama. Have a very good night ahead. We shall see you again soon. Bye-bye.